Good afternoon, everyone. I'm Jason Crosby with SHP, and I'm joined by Kelly Mooney and Mike Scribner. We'd like to thank you for joining our webinar today on key tort reform updates from the 2025 Georgia legislative session, specifically SB 68 and 69, presented by Michele Madison with Bradley, Arant, Boult, and Cummings. Before we dive in, just a little quick virtual housekeeping. To keep things running smoothly, everyone will stay muted with cameras off. So if you have a question, please use the Q&A feature at the top of your screen. We're also recording today's session, and the link will be available on our website in the coming days so that you can revisit it or share it with colleagues. So with that, let's go ahead and get started. Michele, the floor is yours.
Okay, great. Well, let's go ahead and move slides. And so today's session is really going to focus on the law that went into effect earlier this year, with a focus on the fact that Georgia has had some of the highest jury verdicts than anywhere else in the United States, and it was becoming incredibly difficult to recruit companies to come to Georgia and open offices here because of the jury verdicts, the insurance costs, and the rising costs related to that workforce. And if you all remember, for many, many years, Georgia was listed as the number one state to do business in. If you went into the Atlanta Hartsfield Airport, there was a massive billboard that welcomed you when you came in, touting the fact that we were the number one state in the United States to do business in. And because of the jury verdicts and what was happening from a litigation perspective, we had lost ground. So there you go. And so the governor and the lieutenant governor both agreed that this was going to be the number one issue that they wanted to resolve in that last legislative session, understanding and acknowledging right out of the bat, right out of the gate, that they're not going to put in place caps on the actual damages that can be obtained by a plaintiff in the event of an injury case. So we knew going into the discussion for the legislative session that while we were going to work on tort reform, and there had been a lot of committee work completed before we ever got to the legislative session, that we were probably not looking at, hey, it's not going to have a law that says you can't exceed 250,000 in damages or anything, or 350. We weren't going to see anything like that. And so going in, the focus was really on, all right, well, what are some root causes that cause these jury verdicts to be so high? Because when you have a high jury verdict, some of which exceed insurance limits, then the dollars come out of those companies' pockets, or they come out of the insurance companies' pockets, depending upon how they negotiated that settlement. And that cost gets passed on to the consumers that use those service providers in order to cover that kind of expense. It's also a concern, no one wants to be always concerned about, I'm going to get sued for everything, and lots of frivolous litigation that could lead to potential damages. So we focused on things that really looked at how did we get to these numbers that were happening in the jury verdicts. And so they focused on the damages side. There's two different types of damages. There's the economic damages, which is, all right, I've been injured and I have medical expenses. I had to go to rehab. I have therapy. I've lost my wages, lost my income. I couldn't work during that time period. Those are direct expenses that I'm incurring or through losses that may have resulted from an injury. So let's say I'm in a car accident and someone sideswipes me and I get injured and I have to go to the hospital. So I've automatically got medical expenses there. I've got expenses for all my providers. I have to replace my car and I couldn't work for 6 weeks. So those are all direct economic damages that I sustained as a result of someone else's negligence in sideswiping the car. Non-economic damages are things like physical and emotional pain, discomfort, anxiety, distress. So the types of things that you feel like they're more intangible, but they're taking away from someone's enjoyment of life or companionship with others. And so those are more non-economic, and it's harder to put a dollar amount on a non-economic damage. So economic damages, I can say, hey, I get paid $1,000 a week and I couldn't work for 6 weeks. Here are my damages on that. Or the car repair costs $200,000 or $2,000. And so here are the damages on that. Those are easier to quantify. Non-economic damages have not been easy to quantify. And so what's happened historically in Georgia is that when a plaintiff's attorney brings these cases and you have someone who, let's say, has been in a car accident, an accident as it is, and they are injured in a way that they are unable to go to work or they're unable to go to things that they enjoy, their football games, whatever it may be. And as a result of that, they've lost the fun of being around other people and doing things with others. So there was a recent case in the middle southwest area of Georgia. And one of the things that the attorney argued was, well, this person was a grandmother and she couldn't go to the park with her grandchildren anymore. So it kind of ties on those heartstrings. And then they asked for a very large amount of compensation for those non-economic damages. And that's where we've just seen it get exponentially higher, I feel like, every year, to the point that Georgia was the number one place where no one wanted to have a lawsuit. So let's go to the next slide. So in order to address those damages, because this isn't just about, okay, from a healthcare perspective, we want to keep insurance costs reasonable and try to keep it lower. This impacts the industry and economic development for the entire state. So one of the areas that we focused on were these economic damages. So if I go to the doctor and it costs $150,000 for my surgery and the hospital visit and my rehab and getting home and having home therapy, those are healthcare expenses that I've incurred, right? Well, historically, there were times when a plaintiff's attorney would take the bills and instead of saying, well, the insurance company paid $150,000 for the surgery and the rehab and the home health, they would say, well, the hospital billed $275,000 for the surgery and they billed, $100,000 for the rehab and the home health nurse was $50,000. And we all know, as people on this call who work in healthcare, what we bill and what our charges are not what we bring home. So we weren't paid $100,000 for home health or $50,000 for home health and 100 for therapy. We were paid probably 20,000, maybe 15,000. So the government said, let's really look at what your actual medical damages are. Let's look at those real medical expenses of what was actually paid. And we'll talk more in a few minutes about litigation that gets financed by other people through the lien business. But the government and the courts will now say, all right, show me your invoices. Let's see what was actually paid to the provider, not what was charged. And if there, for some reason, something wasn't paid, so like if I go to a prospective payment system hospital and the charges are under a DRG method, they're going to estimate what the insurance company would have paid for that service. So let's go to the next slide. And so when they do look at that on the medical damages side, the evidence that the court is now going to look at, instead of just these are the billed charges, is, okay, did the patient have a lien case, meaning they were in a car accident and someone said, hey, when we settle this case, we will pay you. And here's the letter saying that we are going to pay you this amount for delivering services to the patient because their health insurance isn't going to cover it because it was caused by a third party. And so let me give you an example. I'm going to use car accidents for a little while and then we'll get off the car accidents. But car accident, individual that hits you doesn't have insurance, although that's illegal in Georgia. They don't have insurance. So now you've been injured, but your health insurance has an exclusion that says, hey, we're not paying those bills because a third party caused this and they should have had insurance. So now you have no money, right? And so the attorney or whoever's helping you with your case says, all right, well, we need you to get care and treatment. So we're going to send you to this physician. We're going to give them a letter of protection and say that we're going to pay them, especially if we get a settlement from this claim. So they can use that letter of protection. They can look at charges for the plaintiffs and the healthcare expenses on an itemized basis, but then they're also supposed to be looking at what were the actual medical expenses that were paid. Sometimes as providers, we sell our accounts receivables. So we may have 300,000 in outstanding accounts receivables and we sell it to a factoring company who will buy it for like 5%. And then they'll go work it and try to collect it. And we get immediate payment for 5% of our receipts. If they sell it, the court can look at what that third party was that bought it. What was the total dollar amount of the accounts receivable related to this individual patient and who the referring party was. So like, did the attorney refer this patient to this doctor for purposes of the accounts receivable? And then was there someone related to them that bought the accounts receivable? So they're looking at that string of relationships to see, are these invoices reasonable to determine what the medical expenses would have been for this type of treatment that this patient received, especially if they're doing a lien case.
So
they'll
Michele,
look at these.
does that include when you sell to the injury finance company? Because always those are, I'm sure you're about to cover this, but those are, you can do it under, you can wait for your payment or you can sell it for a higher discount now. Is it also covering that?
Yeah, if you sell or factor your accounts receivables in any manner, it can be evaluated. It's not mandatory, it's just some of the items that can be discovered during discovery.
Got it.
So, like historically, when those lien cases would arise, you'd have a doctor who would say to the attorney, I'll take a lien on your settlement and I'll deliver care to the patient, right? Sometimes there's a third party lien company that's going to actually pay the doctor and they take the lien on the settlement, which is
Right.
a little cleaner. And the reason it's a little cleaner is if the doctor has a financial interest in the outcome of the settlement, then that's now he's got a conflict of interest. Like he shouldn't be treating a patient he has a financial interest in the outcome. So it's normally the third party lien company owns the account. They pay the provider some percentage of charges for their service. They hold the lien on the settlement amount and then they get paid when it's over. But the courts and the government were concerned that in some of those cases, the charges that the doctor was charging to the lien company may not have been the same charges that they would have charged to a Blue Cross Blue Shield or a United or an individual third party who didn't have a lien, right? They may have increased their charges because most of those lien companies, when they negotiate a contract with the doc, they say, hey, we'll pay you, I'm going to make up percentages, 47% of your billed charges if you will treat this patient, and then we'll take the lien on the settlement, you'll get paid right away. Well, some providers, according to the government, would, let's say that procedure, normally they would bill Blue Cross Blue Shield $50,000 for the procedure, but because it's a lien case, they were billing them $75,000 because they were getting paid a percentage of their billed charges. And the government and the courts are trying to cut back on that to figure out what's the real third party expense that would have been applicable. And so they're going to look at that lien contract. They're going to look at what the normal rates are. They're going to look at how much the accounts receivable was that was sold to the lien company, trying to decipher whether or not the amount is appropriate at the amount of billed charges or the amount that was paid or an amount that you would have billed to an insurance company. And it doesn't mean the court has to take all of that information, but these are the types of things that we're seeing requested through discovery. Does that answer your question, Mike?
Yes, it does. Thank you.
So we can go to the next slide. So on the non-economic damages, one of the areas that we were running into trouble with in the state of Georgia is that if I was a plaintiff's attorney, I am trying to get the highest award for my client, our patients, my client, that I can to address the damages that they sustained as a result of the negligence of someone else, right? And so they're trying to set in the mind of a jury, who's supposed to be a jury of peers, that, okay, this individual has suffered in these ways, and these are the damages that they have sustained. And a lot of those are non-economic damages, like the grandmother couldn't go to the park with her grandchild anymore because she couldn't walk. People couldn't go to football games. They couldn't go out at night because now they were fearful of whatever happened. So lots of circumstantial evidence kind of painting that story of what that person's living with, and then throwing out numbers of what they think the damages are that this person should get to make them whole from the damages that they received. And what we were seeing is what's called anchoring, and I'll talk about that in more detail in a second, but where an attorney would try to anchor the jury's mind around this person has suffered so much and there's no way to make them whole. And so the only thing that could make them whole is $100 million or some crazy number, right? And I've even seen it where somebody gives this opening statement and they use, I don't know if y'all remember this, but the MasterCard commercials from years ago, and they would show like MasterCard, you're using your MasterCard to buy plane tickets and you're using MasterCards to buy tickets to a football game, the national championship game, and then they show a picture of the person at the national championship game and it says priceless because it costs this much to get the airline tickets, this much to get the tickets, but this experience of being at the national championship game, especially when you win, is priceless. So I've seen attorneys say, there's no way to put a value on the damages my client has sustained. There's no way you could give them 50 million, 100 million, 150 that'll ever make their lives the same. And that's bringing the jury's mind to a number that's pretty darn high in comparison to actual damages. And so one of the focuses of this tort reform law is to prevent that from happening, to prevent the attorney from saying in the beginning of the trial, my client did XYZ Monday through Sunday, and they love this and they love that, and showing pictures of all their family and everything that they did, and then saying they'll never be able to do that again, and you can never pay them enough to be able to do it. $300 million won't make them well. You can't do that anymore because now you've got to wait until after the close of evidence to be able to rationally relate your request for what you think the damages are to something that is reasonable related to the actual economic and non-economic damages that would have been sustained by this individual. And if you say something in opening that runs afoul of it not being rationally related, you could get in trouble with the courts. But let's say that you have real numbers. Let's say that you can say, I know my client has $300,000 in medical expenses, and we know that they had to go through 6 weeks of being off work, and we know their damages are this much. That's a rationally related number, but you can't change that number when you get to closing and say, well, they had so many $100,000 in actual damages that they actually took out of pocket or had a loss of wages. Now that's worth $50 million in closing arguments. You can't do that either. So it's called anchoring. Let's go to the next slide. And anchoring is where the plaintiff's attorney anchors the jury's mind on a number that is not reasonable nor rationally related to the actual damages that were sustained by that individual. We had a case, gosh, it was probably 6 months ago, 7 months ago in Southeast Georgia. So it was before this law went into effect. And the plaintiff's attorney's opening statement was, this is a $37 million case. And I will tell you that for whatever reason, there were lots of people in the courtroom that day. And I don't know if it was because the press was following the case or why, but it hit social media so quickly that I was getting text messages like every 10 minutes from different physicians saying, how can you have a $37 million? And it was just what the plaintiff's attorney said in their opening statement. At the end of the day, they never proved $37 million in damages. So they could not do that today with this new law. The new law is to say you have to provide evidence of the damages sustained. And if you're going to throw out a number to encapsulate those non-economic damages that we can't show an invoice for, it has to be rationally related to the actual damages that are being sustained by the individual. So the other thing is when you go to pick a jury, which can be a long process and sometimes it goes a little shorter, but you can't say to a jury, do you think that you would award $100 million for an amputated leg? You can't say that. What you can say is, do you have any objections to awarding damages that exceed a certain amount, just to see where their mindset is? But you can't anchor them on the concept of, and it's worth $37 million, or would you give an award of $37 million, trying to get them to already have in their mind the amount of damages you're looking for. So that kind of strategy, that way of trying to get into the jury's mind is gone now in cases, which is good because the goal is that it brings it down. What's fascinating is when you talk to the jury consultants, if you had a jury and the plaintiff's attorney says, I think my client deserves more than $100 million, some of the jury consultants would go and poll the jurors later to find out, like, okay, well, when you did give your decision, did that $100 million impact you? Or why did you give the amount that you did? And it's fascinating to hear what juries say, because some jurors said, I didn't think that it was worth that much money, but the plaintiff's attorney said it was worth $100 million. So I thought I would just split it in the middle and give $50 million, without any concept that, hey, by the way, the car cost $10,000 and their medicals were $50,000. No rational realization to that. Just, hey, they said 100, I'm going to help the defense. I'm going to go ahead and just split it in the middle. I'm not going to award them the full 100. So just not rational thinking on how to calculate damages has really impacted where juries have gone with their jury verdicts. And that's what is the focus of this tort reform, is trying to bring in the conduct and what is actually laid out to the jury to ensure that damages are real, like numbers. And if they're not real numbers because it's a non-economic damage, then what's a rational, reasonable number that actually relates back to the damages sustained? So let's go to the next.
So, Michele, they can say all that after at the closing argument though?
Only if it's rationally related to the evidence that they provided before. So they can't get up there and say, and by the way, it's still worth $100 million. You can't do that any longer. It's got to be
Got it.
related to the evidence that you put forward before the jury.
Okay, got it.
So this is the best thing, I think, or one of the best things that came out of tort reform is this bifurcated trial concept. So for us that are healthcare providers, and I should say for y'all that are healthcare providers, when we get into a trial, and let's say that something did go wrong. Let's say we have a surgery and there's a retained sponge and nobody caught it for 6 years, and now there's an infection and the person's septic and they had all these medical expenses. Okay, I'm just going to paint it pretty bad. And so that's an error. It's just an error that somebody made when they were counting the sponges. And so the hospitals made a mistake. And the jury, the way it worked before this law is that we would be going into a jury trial and the plaintiff's attorney would be bringing forward all this evidence about, well, how many times has the hospital had retained sponges? How many times has this physician been involved in a case that had retained sponges? It's such a simple thing to do to count sponges and paint this very bad picture of what the defendant looks like from that standpoint. And in those instances, we are going through a trial where they're bringing forward witnesses, testifying about our hospital operations, testifying about our policies and procedures, and laying everything out there for the jury to decide, okay, well, did they do something wrong or not? And knowing the whole time that, yes, we missed the count. That's a problem. We missed the count. And then because the jury has now heard about all the damages and the pain and suffering the patient had over all these years and the number of surgeries and CT scans that they had trying to find this retained sponge over 6 years, not knowing that that was the cause, all of that also pulls on the heartstrings of the jury. And so then the jury then gets evidence in the same trial prior to this law about the damages. So now they're deciding, well, I just heard the story about this lady for 6 years was in all this pain, couldn't do this, couldn't do that. Life was terrible. She got depressed, all these things. And now I get to decide, because the hospital should have made sure that count was right, or the physician should have made sure that count was right. I get to decide how much to pay her to make her whole for those 6 years. And it all comes together with a lot of emotion. And remember, before this law, the plaintiff's attorney could talk about 25 million, 50 million, 40 million. And so now these numbers were in there and we were getting really high jury verdicts. This bifurcated trial concept is one where, okay, we can try a case. And in my example before, you probably had the hospital and the physicians as defendants in that case, right? Retained sponge, because you're going to have the hospital staff of the techs and the nurses and the surgical circulators, and then you're going to have the doctor who's the captain of the ship overseeing the counts. And so you're both going to be at the table. If for some reason one party settles out, there's only one party left for that jury to award damages against. And the jury doesn't know about settlements and other things that have happened before. They just know I've got the hospital at the table. They don't know where the doctor is. And so they award this very large amount to make the patient whole. So here we will be able to do a bifurcated trial where we could say, all right, let's just try the facts about whether or not we are or are not liable. Or even better, you could say, look, we know we messed up on the sponge count, so we admit that the sponge count was done in error. Now we want to just do a trial on the damages. And the reason why that's beneficial is now the jury's not hearing about all the pain and suffering and all the things she couldn't do for 6 years. Now they're hearing, okay, she had 5 surgeries, and during those 5 surgeries, the medical costs were $500,000. She couldn't work for 12 weeks. Her compensation was X amount. It focuses the trial on just the monetary damages without the additional emotional, intangible things that come in to impact a jury. Of course, they're going to know what the underlying cause was. There was a retained sponge, but they're not deciding liability. They're just deciding damages. So if you go through both phases, before the pretrial order, you would ask the judge, hey, we want to try whether or not we were negligent first, and then we will do damages second. And if the other party doesn't object, the judge awards it. And so the first phase is just to decide, is there any fault here, right? Did anybody do anything wrong or negligent that someone should pay? We're not talking about money. We're not talking about what happened from a non-economic perspective. just talking about negligence. And then if the answer is yes, someone was negligent, then you go into a second part. Now, the part that's a little weird about this is you have the same judge and jury, so they're going to have some information, but the jury instruction should focus the jury that now you're only deciding on damages based upon the evidence that's submitted related to damages, not large numbers that are thrown out for anchoring. And then let's say the jury says, yes, the hospital's negligent, and yes, we're going to give damages. And let's say that they give damages of $3 million. There is a potential for a third phase in this bifurcated trial where the plaintiff could come back and say, all right, somebody should have settled with me 3 years ago. I shouldn't have had to bring this trial. And so I want my attorney's fees. I want the litigation cost because the hospital was wrong in keeping this trial going. So now I'm going to ask for punitive damages or attorney's fees related to this trial. That normally goes before the judge, not necessarily a jury. Attorney's fees have to be determined if they're reasonable. So that usually goes before the judge, but that's the third phase. It doesn't sound like it's all that different when you say, oh, well, you still have to try the negligence, you have to try the damages. But the jury instructions of what they're deciding in two different trials and changing the determination of what they're going to look at should impact the damage side, plus that in combination with they can't anchor anymore. Let's go to the next slide.
Michele, not to interrupt you, but I mean, answer this later if you want. Is it too early to tell whether or not the impact of this is playing out the way it was intended?
Oh, yeah, it's way too early.
Okay.
Yeah, it's going to take us a while.
Got
It took us a long time to get to where we are, being the worst place for litigation. It's going to take us a while to get out of it.
Got it.
Now, if you ask for a bifurcated trial, and remember you have to do that before the pretrial order, the judge can reject it if there's opposition to it, and if the plaintiff is a minor and it has something to do with sexual offenses or something that's going to cause them psychological or physical anguish, and if it's less than 150,000. And the reason for that is a public policy reason. If you've got a minor who is having to testify related to something that was psychologically harming to them, the judge and the court systems do not want to have those minors have to testify twice. And so they could say no to a bifurcated trial. So let's go to the next one. So this one surprised me, even though I know lots of plaintiffs' attorneys. We can go to the next slide. On the attorney's fees, this is going to eliminate being able to capture attorney's fees twice. So, you see the billboards and you see the buses, and if you live down in near the Chatham area, if you get off on 516 and go south, there's like 27 billboards that have plaintiffs' attorneys on them. So as you look at that, a lot of times those attorneys have contracts that say, we'll take 40, you don't pay unless we recover for you, and we'll take 40% or 30%, but 40% of your settlement proceeds. So if we don't win, you don't pay, but if we win, then you pay. And so the court is trying to close a loophole where, let's say I've got a case and I'm a plaintiff's attorney and I'm going to get 40% of whatever comes out, right? So I try the case and we win big. So let's say we win $10 million. So I'm going to get 40% of $10 million. But you know what? The defendant, the hospital, never should have fought me on this case. They knew they were wrong. That doctor never should have had medical staff privileges. He was from out of state, not licensed, So I'm going to go back and ask the judge to also award me attorney's fees because they were litigious in not cooperating. So now they go back and say, hey, my attorney's fees should be paid. So now they're getting their 40% plus fees. So that's out the door now. You're going to get paid once, not twice, if you're a plaintiff's attorney. And it's going to require for it to be a reasonable fee. If you have a contingent fee agreement, it's not supposed to be admissible as showing that, yes, that's a reasonable amount. They're actually going to look at how many hours did you spend, what was your hourly rate, what were your expenses on the trial, and really try to determine what is a reasonable amount for attorneys to get paid. So I have seen 2 of these so far after the tort reform, and I was surprised where they came back and asked for attorney's fees at the amounts that the courts were still awarding on attorney's fees. I was very surprised. So we'll see if that goes down over time. I think it'll take time for this to actually have an impact related to the cost. Let's go to the next slide because this one has to do with strategy, and I think this is really important. And we have used this in a case already. So it used to be that when you had a lawsuit and you had to answer the lawsuit, you would answer the lawsuit and you would go to, you're the defense, you're answering the lawsuit, you prepare for a lawsuit, and sometimes it takes years. So that case down in Southwest Georgia was on for what, 7 or 10 years, with some crazy amount of time where that case was kept going. And some of these cases do take that long. And so you've answered the lawsuit, you've gone through all this discovery, you've done all these depositions, you get to the actual trial, you've picked a jury, and then the plaintiff says, I'm not sure I really like that jury, and they do a voluntary dismissal at trial. And now they can come back and refile. And so the court said, this is too much. This is creating too much cost in the litigation system. So if you're going to do a voluntary dismissal of your case, you have to do it within 60 days after receipt of the answer. So if I'm a hospital and I get sued, I have to answer that lawsuit in 30 days, right? So the plaintiff's attorney would need to decide in those next 60 days, do they think they really have a good case and are they going to proceed with it? Or are they going to do a voluntary dismissal and try to rework their case? So this is important from a cost-saving perspective in the litigation system. So voluntary dismissals can either be 60 days after the answer now or by mutual agreement of both parties. So we can go to the next slide. This is the biggie. So the motion to dismiss. So right now, if I'm the hospital and I get sued in my example, right, and I have to answer within 30 days, if I think this case has no merit and there is no reason for this case to be brought, I want to file a motion to dismiss. Well, in order to file a motion to dismiss legally, I'm supposed to file that with my answer. Like, it needs to be filed with the answer. If I don't file it with the answer, my motion to dismiss is likely gone, right? Well, the problem is that by the time I file my answer and I have to do my motion to dismiss at that time, I've got to do discovery. And so while the motion to dismiss might be pending, there's a whole bunch of discovery going on. There's depositions being taken, there's documents I'm having to produce, lots of litigation expenses ongoing. And yet I might get my motion to dismiss and none of that would have been necessary. And all of this cost that I've incurred would have been for nothing. And so they've changed it now where instead of filing an answer with my motion to dismiss, I can now just file my motion to dismiss and say, look, court, I don't think that this case has merit, and I think you should just dismiss it. And so the court has to listen, look at the motion to dismiss. Everything gets stayed in the meantime. So no depositions, no discovery, no interrogatories, no production of documents. I'm not spending money to defend myself because I don't think it's a real lawsuit that should go to court. And so then once the judge says, we agree, there's no merit behind the case, we're going to dismiss it, I'm done. Now, if the court disagrees and says, there's an issue of fact of whether or not your nurse should have been the one counting the sponges, so we're going to let it go through, 15 days after the judge makes that order, I then have to file my answer denying liability, right? So the other time that the discovery is stayed, as long as the motion to dismiss is ongoing, the court is supposed to rule on the motion to dismiss within 90 days. But if they don't, then the plaintiff's attorney can petition for the court, filing a motion asking them to go ahead and either rule on the motion or allow discovery to commence. So discovery stops until the judge actually says, all right, I'm ruling on the motion to dismiss and now you have to answer, or discovery could commence if the other party asks for it too after the 90 days following the briefing of the motions. Let's go to the next slide, because if my motion to dismiss is because they've sued me in the wrong jurisdiction or the wrong court, or I didn't actually get served with the complaint properly, or they didn't join the right party, so I filed a motion to dismiss because one of these failures occurred, it is possible that the court will say, we are going to consider the motion to dismiss, but allow limited discovery on whether or not jurisdiction, venue, service of process, or the right party is proper. So while it's still cutting a lot of cost, it's limiting that discovery to the underlying fact of, should the court even be hearing this case? Is it even in the right court? So on those instances, you may see some limited discovery, but it'll be nowhere as costly as depositions and producing documents and doing interrogatories, which is a huge cost and very expensive for everybody involved. So that actually, I think, will have a serious impact on cost of litigation, which hopefully will help all of us with our insurance premiums by cutting the cost for the attorneys and the individuals that are working on the cases. So I'm going to flip gears to the next slide, to a law that is actually going to go into effect January 1st, 2026. It is part of the tort reform laws. The government was very concerned, and when I say the government, the state was very concerned that there were third parties out there that were looking for plaintiffs to then fund their lawsuits and then take a percentage of the settlement amount or the jury verdict amount so that it's like a profitable business, right? Like a bank, I'm gonna loan you money, and then when the settlement comes through, I'm gonna get a percentage of whatever your settlement is, and I could possibly make more money than what I loaned you. And the government was concerned that one of the reasons that Georgia was having such increases in litigation and so many cases being brought to the court system was because people were literally funding it. And because they were funding it, they were pushing it to get all the way to the courts so they could get their best jury verdict they could possibly get. That ties up a lot of money, a lot of court system time, and a lot of processes and funds for both parties on both sides. But if I'm a plaintiff and someone's funding it for me, I don't have anything to lose. So the government's also did some reviews, and they believe that a lot of the entities that were being funded to then fund litigation were being funded by foreign governments. And so they passed this law that when you have litigation financing, these individual companies or entities must now register to do business in the state of Georgia. So before they just came in, they would go to wherever they went to find plaintiffs. They would give them funding for their lawsuit and take a percentage of whatever was recovered once the jury gave their verdict, or if there was a big settlement or whatever it was. Maybe there's just a little settlement, but they got whatever they got. We didn't know who they were. They were just here. Now they'll have to register, and they cannot be owned or affiliated with a foreign government or a non-government person, a foreign non-government person that is engaged in litigation financing. So this will all really come to head January 1, 2026. And we can go to the next slide. The Georgia statutes now have an entire section just on this litigation financing. So it's under Article 7. And basically, there are certain contracts that the litigation financer now has to have with the plaintiffs. And it also allows the plaintiffs to be able to terminate those contracts and get out of the contracts even after the litigation has started. And there are very specific provisions that have to be in the contracts. So to say that the state is taking hold of this type of industry in Georgia is an understatement, because your contracts, if you're a litigation financing entity, will actually have to conform to state law on the provisions. There's no negotiation on those provisions. So the litigation financiers also prohibited from engaging in certain acts. And these are the acts that the state government thought was impacting the cost of litigation in the state when you've got these companies coming in and funding it. So they don't want them being involved in any decisions. So they can't come in and then go to an attorney and say, hey, for every one of the plaintiffs that come to you, I'll fund it. You give me 40%, but I want to sit at the table as we make decisions because I've got 40% on the line. They will not be permitted to do that. They also won't be able to pay a commission or referral fee. So I had heard rumors that there were people out there who would go to attorneys and say, hey, I'll bring you plaintiffs if you have them use me to finance their litigation, and then I'll get whatever percentage of their settlement. So I don't know that, I don't have firsthand knowledge that ever happened, but I've heard rumors. And so this is in here that you're prohibited from paying any commission or referral fee to anyone in order to induce referrals for this. The other part, and this was a big discussion when the law was being, when the bills were going back and forth, is there was concern that the plaintiffs who were being funded were vulnerable, right? They've been in a car accident, they're out of their job, they don't have income coming in. And then here comes somebody who says, hey, I'm going to pay for this litigation so that you can be made whole and you'll be fine and we'll get this money. And it was so wrong that you were damaged. And then they get, let's say, $100,000 settlement. And the litigation financer says, okay, well, we got to pay the expenses first. So that's $50,000. And oh, my fee was 90%. So I'm taking 90% and you get 10% of what's left. And so there was concern that the plaintiff, who's the vulnerable party that was actually damaged, isn't even getting anywhere near a portion of their settlement amounts. So this law requires that the financing entity cannot take more than an equal share of what the actual plaintiff is going to take home. They also can't falsely advertise. They cannot hire someone to go out and find plaintiffs. So it's kind of like, I guess, last year when MARTA, on a totally another note, if any of you have been in Atlanta and you've seen the MARTA buses, they used to have pictures of alcohol advertising, vaping, and attorneys. And they decided at the MARTA level that no longer would they have attorneys or vaping or alcohol on the side of their buses, so that we weren't advertising to individuals. And so you also can't advertise false information like, hey, if I finance it, you'll definitely get $3 million or whatever the false advertising would be. And you can't require someone to solicit for you. You have to maintain a contract with the plaintiff if you're a litigation financing person. And you can't, as a litigation financing entity, waive the remedies on behalf of the plaintiff. The plaintiff retains their rights to make decisions about how they want things to come out. They can't offer them legal advice, even if the person that's doing the financing is an attorney. And let's say I'm a litigation financer and the expenses of this litigation far exceeded the amounts that we got back, so I didn't get hardly anything. I can't file with the credit agency that, hey, this plaintiff now owes me money. You can't do that at all to the plaintiffs because they're the vulnerable population. So if we go to the next slide, the state has created these laws by having these companies register with the state, by having them have to have specific contracts that meet the state laws. That's a consumer protection area, and then making sure that they're not taking home more money than what the plaintiff gets, and that they're not involved in the decision making nor paying for referrals of patients to be sent to them so they can then capture the dollars from the plaintiff's damages. So the legislation is really intended to be both a consumer protection as well as a means of trying to mitigate the amount of cases that are being pushed all the way through the court system, many of which that may be frivolous. And so if someone brings frivolous litigation because they're doing this litigation financing and they just want to push it until the very, very end to see if they can get a settlement, they will be responsible for any fines, penalties, and damages if the defendant files a motion or a complaint for frivolous litigation, because you can countersue someone for frivolous litigation, and these litigation financing companies will be on the hook for it. So I'm going to flip gears now and to the next slide and talk about negligence.
Yeah, Michelle, before you do,
Yeah.
do you think that's, I mean, obviously that injury finance is just a little cottage industry, and it's a little bit of a revenue source for some of the audience. Do you think that whole industry is just going to get gutted by this, or where do you think that heads?
I do think we're going to see a decline in that kind of litigation financing. I do think that what you'll see are more protections and more transparency about what's happening. Like, you will know what I usually see are lien deals, right? You will now know if a litigation financing company is involved in the case because they'll be registered in the state, and you'll know what's happening from a plaintiff's perspective as far as whether or not they're being pushed to go to court on the litigation. I think that you'll see more discovery in litigation focused on who is pulling the strings on the dollars behind this case, especially on frivolous litigation claims, because that's been a big question. Like, why do they keep pushing these? I think it's different than the lien cases that a lot of providers have. I think the lien cases where you've got a lien company who says, I will pay you, doc, and I'm going to take a percentage from these patients. The physician then is being paid for the services, and the lien company is the one that's on the hook for figuring out if the settlement's going to happen. And I don't think they'll go away as much as just straight financing companies, but I do think it'll diminish some.
Gotcha. Interesting.
Yes. So now I'm going to flip gears to negligent security. And the reason I wanted to include this is it was a material part of the tort reform law. It does impact all of us as companies that own space and premises and operate on. And this was actually the last part that was negotiated and was fought back and forth during the legislative session. So there are lots of people out there who were saying, look, people come into my business or come on my property and they'll fall or something will happen to them that I didn't have any control over, and now I'm getting sued for it. And when I say they fall, like they fell over something that no one knew was there, could not have possibly known. And so they were trying to limit when someone can sue someone else for negligent security. So let's go to the next slide. So they put in place levels of knowledge that the owner would have, and whether or not, based on that level of knowledge, they should be responsible for damages to a third party that is injured on their premises. And so I included the direct language out of the code sections just so you have it, because they made it very narrow. Like the owner has to have particularized warning of imminent wrongful conduct by a third person. So they actually had to know that here is this guy who normally engages in criminal conduct, who's on my campus all the time, and he sometimes carries a gun, and I know that, right? So I have an obligation to protect the people who are there. Let's go to the next slide. The other definition of knowledge is related to prior occurrences of substantially similar wrongful conduct. In other words, you had other things happen on your premises that were sufficiently similar to the issue that happened that gave rise to the damages. So in other words, let's say that you had people on your premises that you knew were shooting guns at targets, and you allowed it to continue, and lo and behold, somebody picks up a gun and there's an accidental shooting on your premises. Was that wrongful conduct sufficiently similar to be able that you would have known that this could arise to a potential liability? And so let's go to the next slide. On the negligent security side, there are two different levels of what an owner knowledge and responsibility is. So there is a negligent security standard for invitees. That means I have invited someone to come on my premise for the purposes of conducting business, right? It is beneficial for both the invitee and it is beneficial for me. So that is our physician practices. That's our hospitals. Those are the individuals that we have invited to come in, be our patients, come to our facility. So if they come and they're injured by some wrongful conduct of a third party, and we need to know whether or not it was reasonably foreseeable that this person has engaged in that same or similar conduct on our premises before, or would we have known that a third person was reasonably likely to engage in that type of wrongful conduct on our premises? And if the type of occurrence is substantially similar to other conduct that they've been engaged in, and then whether or not that conduct actually caused the injury to the person. So when I think about this, I think about those of us that have parking lots, and we know that after hours, there's a group of gang members who take their cars and they come to our parking lot and they do donuts, and then they drive really fast down the road, and then they come back and do more donuts, and they wind up doing damage to other cars in the parking lot. Do we have knowledge that they were there? Were there prior occurrences? Was that kind of reckless driving illegal and wrongful conduct? Those are the types of things that might lead to some potential liability for the owner. If the invitee is a patient, they're there, their car gets damaged, and we knew these people were doing that, even though it was after hours. Let's say it was like 5:30, so the patient was still there because we were running late on appointments. So let's go to the next slide. In order for the invitee to be able to receive damages from us, they actually have to have sustained damages that were a foreseeable consequence from that example. So doing the donuts, the damages to the car, that the wrongful conduct of the individual was foreseeable because they've been doing it every night at 5:30 for 6 weeks. And then we didn't do anything to stop it. Like we didn't call the police to stop it. We didn't put up notices that no one is welcome after 5:30. We didn't do anything else. So if we fail to take any reasonable, ordinary care to stop it from happening, then we could see liability as the owner of the property. Let's go to the next slide, because now we're going to talk about licensees. So this is where somebody licenses space from us. This is for their benefit, okay? And so in order for us as a landlord or licensor to be responsible, the wrongful conduct that caused the injury has to be reasonably foreseeable, and there has to be a particularized warning of imminent wrongful conduct. And so the best example I can give you here is there were hotels that were up and down a road, and one of the hotels had had thefts and break-ins into cars, but it was maybe 2 blocks down from this hotel. And lo and behold, an individual's car was broken into, and the hotel company was sued. And they said, well, we didn't have any knowledge that there was any wrongful conduct on our space that was substantially similar previously. So here they would not have been held liable because there hadn't been prior occurrences of wrongful conduct on their premises. It was that they controlled. The fact that it happened 2 blocks down the road at another hotel does not mean that owner is now liable. That is very different than the way the courts had treated it previously. They used to treat it like if there was an instance that happened within so many miles and there was no set mileage, they would consider that as to whether or not you were culpable. So here it needs to be whether or not there's a particularized warning of imminent wrongful conduct by a third person on your premises. And was it reasonably foreseeable that that conduct was going to happen? And then whether or not we didn't exercise any care to remedy the situation. So let's say that we had street lights and lights in our parking lot to prevent thefts, but the lights were out and we knew it and we never bothered to fix it. That could give rise to some liability for failure to take reasonable precautions. And whether or not the failure to have the lights could have been the proximate cause of the injury to the individual. So the standard to be responsible for negligent security is much higher now, which will likely reduce the number of lawsuits and the number of potential jury verdicts related to that kind of claim. Let's go to the next slide. There's also exceptions to liability. So if someone trespassed on your property, so remember the cases back when somebody would try to break into someone's house and they would fall down a flight of stairs and then they would sue the homeowner because, hey, they got injured on the stairs. And we used to all think that's crazy, and yet they would get some award or settlement. So now if someone trespasses on your property, they cannot get damages, which is just common sense that I'm glad it's now actually in the statute. If it's an injury that was sustained somewhere else, obviously you shouldn't be held liable for it. If it was an injury that was sustained, even if it was in reasonable distance from your property, but it's not property you controlled, then you're not responsible for it. And if the individual was a guest of a tenant that you were evicting, so let's say you have rental houses and you're evicting a tenant who's not paying their rent, and they had a guest who is injured at the property, they can't sue you because you were in the process of evicting them in the event that guest was engaged in some wrongful conduct on your property. And then any injury that is incurred would have to have been committed, could not be committed when they were trying to violate the law. So if they were violating the law on your premise, they shouldn't be receiving benefits from you as the owner. And if there is an injury that's sustained in a single family residence, then, or if you knew that there was a potential particularized warning of imminent wrongful conduct and you called 911 and tried to get law enforcement involved, there's also an exception to liability there too. So there are lots of exceptions. There are lots of limitations of when you can actually recover. And the goal is that that will reduce the number of these cases that were being filed against owners of property, resulting in pretty significant jury verdicts. Let's go to the next slide. If you're an owner of property, what's really important is that you do engage in reasonable care of your premises. Like, don't let the lights in the parking lot go out or get shot out without getting fixed. We do need to make sure that we are engaged in the ordinary course of business, protecting the individuals that are invitees to our property and those that we license to use our property. And then we need to, if we were in court and somebody sued us because their car was broken into in our parking lot, and let's say 6 months ago another car had been broken into, so now there's a prior occurrence and it's being broken into by these teenagers, and we know who these teenagers are because we saw them on our cameras. And someone sues us because now their car's been broken into. The court's going to look at whether or not we had knowledge that there was wrongful conduct happening. Did we exercise due care? Did we keep cameras going? Did we keep our lights out there? What security measures went into place? And the court's going to say, were there any other security measures you should have done? So more than cameras, more than lights that are reasonable. And whether or not those security measures would have prevented the break-in, who knows? And then whether or not there's any responsibility for you to protect the individual cars in your parking lot. 9 times out of 10, you've got signage out that says, take in all your belongings. We don't, you're responsible for anything that's left in your car. you're responsible for the safety of all those items. So, and then the other part is the courts will look to see, did you engage law enforcement? So when you had the earlier break-ins, did you engage law enforcement? Did they do extra rounds? Did you call law enforcement when you see someone on the camera? Or if you know that these kids are out in the parking lot, do you call law enforcement? So using a reasonable exercise duty of care will also prevent liability in these negligent security cases. So it's more of a reasonable concept now than what we were seeing historically, which were these crazy cases that we all thought were frivolous because somebody was trespassing or they're the ones who committed the crime and yet they were getting funded and settlement agreements. So that will be out the door. There will be defenses to negligent security. There will be a separate standard that you have to meet to actually recover. And the courts will look at what reasonable degree of care was exercised by the owner versus this extraordinary level of care that sometimes the courts were looking for previously. So I will stop there. Mike, did you have any other questions?
Well, I guess if I was listening to this, my kind of summation thought would be, yeah, it's too early to tell, kind of practical impact it's going to have. But what do you anticipate, like malpractice? Do you anticipate any meaningful savings from this over time? Any adjustments to coverage? What do you think?
Yeah, I actually think that it's going to take a little time, right?
Yep.
Because
Yep.
there are it's going to take a while for these cases to move through the courts, and we'll see whether or not the bifurcated trial cuts down on the amount of the damages that are actually being awarded and we get more reasonable. I think it's between a 3 to a 5 year horizon before the savings can actually be evaluated so that you could have knowledge of what the cost savings will be. I think the fact that you can file a motion to dismiss now without going through all that discovery, that should start impacting insurance premiums faster because the cost for litigation should be less for the defendants. So when we go to renew insurance next year, I don't think we're going to see the insurance premiums go down. My hope would be that they won't go up as much as they have been historically. And then the next year, I'd like to see it stay the same and start ratcheting down because the legal cost on these trial strategies should be less now. We should not be having double attorney's fees paid out. We should not be incurring discovery if our motion to dismiss on frivolous litigation is there. We should not see as much frivolous litigation if it's being funded by third parties that now have to register with the state as a business. And if they're responsible for frivolous litigation, they're not going to fund, or hopefully they won't fund the frivolous litigation. So I think it's a 3 to 5 year horizon. I have not asked the insurance companies yet to see where we are because I think everybody's got, their premiums roll at different times. But this isn't 2026, everything's going to be stable in Georgia. We're talking 2032. We're still looking at, okay, have the costs come down and what's the jury verdict looking at now?
Understood. We're out of time. And so I guess we got to wrap up. In my mind, the follow-up would be, it seems like there's a whole nother level of sort of practical implications on case defense and maybe even risk management in general that, am I right, that we kind of need to rethink some of that in specific instances?
Yeah,
Or
I
is
think
this just, go ahead.
trial strategy is going to be very different now, very different. So I think working with your litigators on just motion to dismiss before you have the answer, give yourself time to be able to pull the facts together internally. You're going to have a different approach to litigation from a discovery perspective at a minimum.
Okay. Well, thank you, Michele. Really appreciate it.
Sure.
That was excellent.
Sure.
Jason.
Yeah. Thanks, Michele, for some really good information. And thank you all for joining us today. As a reminder, we're going to have a copy of today's presentation, and the recording in the coming days will be available on our website. So be sure to download that. And we'll do a podcast recap coming up shortly as well to sort of highlight some of the key points from Michele's presentation. But with that said, we're past 1 o'clock and want to thank Michele, obviously, for joining us today and for all of you for attending. Everybody have a great rest of your day.
Thanks, Michele. Thank you, Michele.